Welcome everyone to today's webinar on patenting software in the US and Europe. I'm Robert Plotkin, a partner and patent attorney specializing in software patents at Blue Shift IP in the US.
And my name is Jochen. I practice before German Patent and Trademark Office and especially European Patent Office. And I run my law firm in Munich, Germany. And I hold a PhD in computer science. So we do all this software, hardware, IT issues.
Yeah, great. We're really excited to talk about lots of substantive issues relating to obtaining software patents. I'll speak from a US perspective. Jochen will speak from European perspective. We'll talk about similarities and differences. Just from glancing at the attendees, looks like we have people from around the world. Thanks for joining us from different time zones, different times of day, wherever you are. Just some administrative things. This will be recorded. So if you want to refer to it later, you can see the recording. We'll post on our sites, on YouTube. But don't worry, you yourself will not be recorded. If you have any questions, you can post them to the chat or the Q&A. That will just be text. Your name won't be there, your video or your voice or anything like that. So just feel free to contribute if you're concerned. You won't be recorded. We will have a Q&A session at the end, but if questions come up while we're speaking, feel free to post them along the way. If we have time and it fits in, we'll answer them along the way. Otherwise, we'll keep things to the end.
Robert, let me start something right at the beginning. Well, I will refer to Europe, which means also I will refer to German patent practice. We have some special issues like utility models and so on. So most of the time I'm going to speak about European Patent Office and also my practice before German Patent and Trademark Office. So this is really interesting, I guess, for the audience, as US and Europe are really the big markets besides China and India and so on.
Very good. Yeah, very helpful. And there's just an introduction to what we'll talk about relating to software patents, patent eligibility, sometimes called patentable subject matter, always an issue in software patents, and be very interesting discussion about similarities and differences between US and Europe. I'll talk about enablement, what you need to describe in a software patent, novelty and what we call non-obviousness, what's called inventive step in Europe, any particular challenges relating to software, a little bit about examination procedure, and of course, some drafting tips. We each have some example patents that we'll talk about at the end. This is really going to be about the substance, what makes a software invention patentable. We are planning to do another webinar about formalities and strategy and tactics. Any other comments before we get started? A little bit about each of us individually. Just very briefly about me. Again, I'm Robert Plotkin. I'm a patent attorney in the US. I've been specializing in obtaining software patents for over 25 years. I represent clients of all types and sizes within the US, from early stage startup companies to established multinational corporations, universities, work with a lot of law firms outside the US, like Jochen's, who are filing in the US, or when our clients need patents in Europe and elsewhere. I really enjoy learning about the latest technology, often years before it hits the market, and helping my clients get strong, broad, defensible, and valuable patents, valuable for purposes such as raising funds, licensing, sale, and of course, to maximize enforcement value in litigation when it comes to that.
Perfect. Well, as I introduced before, my name is Jochen. I practice in Munich, Germany, before European Patent Office and German Patent and Trademark Office. And we also have clients from all over the world. We also have clients in US, like Canada, India, China, Japan. And we have also our colleagues all over the world, like Robert. And we also handle all sizes, namely maybe startup companies or bigger firms, companies. And when we refer to the size of companies, there is one thing I wanted to introduce. Beginning, we have like a discount for startups in Europe, which is quite interesting. So we handle all these. We mainly do software patents, hardware patents, IT patents. We also cover further technical fields, but our focus is really on the software side. And we do like all kinds of patents, like direct filings, original phase entries, also national phase entries in Germany. And also, you can, if you have a PCT application, also file for a utility model. That is us. So pleasure working with you, Robert.
Yes, of course. Yeah, really excited to dive into it now. The first substantive topic, patentable subject matter, so let's call it patent eligibility. We could probably talk all day just on this one topic because I wouldn't say always comes up, but it's something I certainly always address upfront with clients when they come to me. Because for those of you, I'm sure we have patent attorneys here attending, but for those of you who aren't patent attorneys, patentable subject matter basically means that there's only certain types of inventions that can even be eligible for patenting. A song, for example, is something that you can get copyright protection for, but it doesn't matter how innovative the song is, it's not patentable subject matter. And in the US, as you see in this first row, there's a few categories we have defined in the patent statute, categories of patentable subject matter. And those are processes. Very hard to define, though, because not all processes are patentable subject matter, but machines, manufacturers, and compositions of matter. I mean, traditionally, going back hundreds of years, mostly it was those physical products, machines, articles of manufacture, compositions of matter, chemicals that are patentable subject matter. Software, of course, straddles those lines. You can think of software as a process or as something that embodies a process, but it also takes a physical form. And that's why the courts, the patent offices are continuously struggle with attempting to define and determine in individual cases whether software fits into any of those patentable subject matter categories. But let me just stop there. That's the statutory framework we have in the US. If you want your software to satisfy this requirement, you have to demonstrate that it's a process, a machine, a manufacturer, or a composition of matter in the US. You open on Europe?
Well, in Europe, it's quite similar. What we have is a method apparatus, also connected with an apparatus is a method, a system arrangement. And what we have, what is a difference to further jurisdictions, is like a computer program or a computer readable storage, so a data carrier. So typically, when you think of a software, you typically have an algorithm, and that is typically defined as a method claim. And you can also state structural features in that method, say using a processor for carrying out a method. And when you draft the application, you can draft like the apparatus, meaning the physical device, and you can also claim the whole system arrangement where this device is used. So what we have is also exceptions like mathematical methods and programs for computers, presentations of information. And if you look at the third row, you will see that there is an exclusion from patentability for subject matter activities referred to therein only to the extent to which it relates to such subject matter or activities as such. And this is quite interesting about European patent practice and also German patent practice, as you have an exclusion from patentability. but only if it claims the exclusions as such. So you will see that the whole case law and the whole jurisdiction works around these two words as such. So when is there technicality? What is an exclusion from patentability as such? And we will see some examples.
Yeah, I
Yeah,
mean, I think
right.
in practice, for those of you and the audience who aren't in the weeds of this every day, like Jochen and I are, can be hard to get your head around this. But let's give a few typical kinds of examples. Let's say you had a method, a kind of software for doing data compression, right? Taking data and shrinking it into a smaller size. You know, that is a process, you would say. So you might think, well, it's a process. The patent statute in the US says that processes are patentable. Easy. It's an easy answer. Therefore, that data compression method must be patentable subject matter. But in the US, the courts have created a variety of, you could either think of them as exceptions or further refinements to the definition of which types of processes really fall within the meaning of process in the statute and which don't. And that there's never been any really clear dividing lines between the types of processes that are patentable subject matter and those that aren't. One of the reasons for that is that there's a desire to exclude things like pure mathematics from patentability. Most people would agree that just a new type of mathematical formula, even if a mathematician would consider it very new and innovative, shouldn't be patentable because it is too abstract in some sense, or it doesn't have any practical use. F equals ma when Newton first came up with it, right? Really innovative, clearly, but it's not the kind of practical thing we consider to fall within the scope of patent protection. And the challenge with software is you could say, well, all software in some sense performs mathematical or logical operations. So there needs to be a way to draw a dividing line between things that are too mathematical or too pure and those that are practical enough, like a data compression algorithm or an algorithm that controls the brakes on a car, right? That guides a missile, things that control machinery. And we can sit here and say it's easy to look at examples and say we agree that some of these are practical enough to be patentable subject matter and some aren't. But it's very difficult to define rules that draw that line. And that's what all of these cases over the years in the US have attempted to do, and what the US Patent Office's guidelines, which are quite lengthy, attempt to do. And I'll end here before Jochen, I'll let you comment.
Perfect.
What we
Perfect,
do as
Robert.
patent practitioners most of the time from a practical point of view is look at decided cases which have drawn that line and at the patent office's guidelines which rely on those cases and say here are some examples of types of software methods that are patentable subject matter and here are some that aren't. And then when we're trying to argue that our own clients' software is patent eligible subject matter, we'll point to some previously decided cases and say our new claim is similar to those. And that takes a lot of knowledge of the case law and previous examples and how to argue for similarity to previously cases because it's so hard to define rules in the abstract. Jochen?
Or Robert, you were referring to two issues which I wanted to comment on regarding the guidelines. We have the same before European Patent Office, and they're like 1,000 pages, so they are very strict. But there's also one thing I like about them. Well, they tell us exactly what to do. Well, not really exactly. Of course, we have case law which needs to be interpreted and so on. But before European Patent Office, we have very clear rules what we have to provide. And this shows us how the examination proceedings are going. And of course, when drafting the application, we can also consider these guidelines. And I like the clearly structured process of examination. So this is, although the guidelines may be helpful, it's a lot of effort going through them, but I really like them, and it's a great advice. That's as I see it. Well, regarding the mathematical methods, I introduced that we have software patents are typically referring to methods. When we shrink data, it's of course a mathematical methods, but all of us know, well, there's memories involved, like buffer storages, like hardware, and so on, like a hard drive and so on. So this is really the point where we can really where the patent attorneys come into play and have to define really, is this a mathematical method or is it rather a technical method? So before European Patent Office, we have like the overall slogan is provide a technical solution to a technical problem. So whenever the client comes up and introduces some mathematical methods and the like, we will see and go into detail and find those technical issues and make the mathematical method a technical method, which can then be formulated as a claim.
Yeah, no, I mean, this is again why I think we both of us specialize in software patents because the principles may be simple, but applying them in practice to obtain patents is quite complicated because you need to be really familiar with exactly how these rules are applied in practice, including all of the guidelines. And they do differ in the details between the US and Europe. You know, when we file a patent application through a firm like yours for a client of ours and we get a rejection, often the client will say, ask me how to respond. And I'll say on this patentable subject matter issue in Europe, I'll say, let's ask our European associate, because I don't want to attempt to answer that question, no matter how familiar I am with how the US Patent Office would handle it. Even though in a sense it's the same question, the details can be quite different in terms of how they're handled, and it changes over time, right? As new cases are decided and guidelines are updated. Let me just say something on the technical side for those of you out there who maybe you're thinking about your own inventions or your client's own inventions and whether you should try to apply for patent protection on them. Just as Jochen said, you could have something which seems mathematical, but a good patent attorney can either write a patent application which characterizes it in a technical way, can also have methods. I think about educational methods, for example. I'm working on one right now. I have a patent application I filed on for a client that involves what you might think of as educational methods, but it's a method for assessing performance of students that makes use of some really sophisticated software. And so we're focusing in the patent prosecution on the technical details of how the method is executed by a computer. And the reason I mention that is I would encourage people, don't assume that a method whose purpose, let's say, is educational or whose purpose is to perform legal reasoning or do something in business, that can't be patentable subject matter, because there may be details in how that method is carried out on a computer that can be characterized as sufficiently technical to satisfy this requirement.
Exactly, that's what we do. We transfer like non-technical inventions to technical inventions. So this is our job and
This is
our, our passion.
absolutely. We'll be glad to answer more questions. As I said, we could probably stick on that topic all day, but let's maybe move on. Hit some of the highlights here of some of these practical considerations. On the U.S. side, I'll just say that I pulled a lot of these from the U.S. Patent Office's guidelines, which I use all the time to refer to. Why? One, it's based on court cases. It has some legal basis, but more importantly, as a practical matter, US patent examiners use the US Patent Office's guidelines when they decide whether to reject claims for being non-patentable subject matter. And because they use it as the basis, if I submit a patent application, it gets rejected. I then look to the guidelines to see whether the guidelines give me a basis for responding to and overcoming those rejections. And the guidelines provide a variety of factors you can look to to overcome a rejection. One of them is that if a method implements what's called improvement to the functioning of a computer or other technology, that can demonstrate that the method is patent eligible or patentable subject matter. So, Joachim, you mentioned a hard drive or memory. If we can demonstrate that a method uses fewer computations than a previous method or results in more efficient use of memory, we can argue that that is an improvement to the functioning of the computer itself, even if the purpose of the method, again, is educational or something that wouldn't be considered technical. Use of a particular machine, I'll just use this one as an example. Lots of software runs on a general purpose computer, but it's important to always think about in a particular case, did the inventor make use of a special purpose machine, some other circuitry or particular hardware that we can use to say this invention runs on a, quote, particular machine, not a general purpose computer, and that can be enough to demonstrate patent eligibility. So I often, when I get a rejection, look through the list of bases and the guidelines and use them to respond. And also, even when writing the patent application in the first place, I review the guidelines to build in arguments against such rejections to try to avoid them as much as possible.
Well, exactly. We also stick very much to the guidelines because this is really what the examiner or the examining divisions really consult when assessing inventiveness, for instance. And what we have, you introduced a so-called common purpose computer. Well, every now and then I get uh, communication from German Patent Trademark Office where they just say, well, this method can be run on any common purpose computer, and they just don't do even a search. Yeah. So what is interesting here is that typically before German Patent and Trademark Office, they even deny the search. I had such cases, and before European Patent and Trademark Office, they have a more sophisticated approach. They say, well, we still examine novelty and inventiveness, and then we have the so-called convict approach, means with mixed type inventions where we have like non-technical and technical contributions. Only those contributions which are technical are considered. But I will talk about this later on. So, well, summarizing the slide, well, as you introduced, Robert, well, we also in Europe stick very much to the guidelines. In Germany, before German Patent Trademark Office, the guidelines are not that extensive, but we typically file before European Patent Office. And as you said, well, we have to improve like the hardware. Well, we can claim the software, but there needs to be some interaction with the hardware, meaning or the physical world. So what we say, you need a technical contribution to a technical problem, meaning that you don't have to mention the structural features or the hardware features as such, but the claim is interpreted as a whole. First of all, when it comes to patent eligibility, so there is indeed a difference between German Patent and Trademark Office and European Patent Office. And what you could do is that you claim not only a method, but you can name it as it is, namely a computer implemented method, and also in the description highlight the technical effects. So again, referring to hardware issues.
Yeah, yeah. And, it's interesting. I think there was a time in the past when maybe there was more of a difference between the US and Europe. I don't know if you would agree with me if I say the US maybe has moved more towards the European approach. There was a period of time, particularly after the State Street Bank decision in the US in 1998, which really expanded patent eligibility very much to include business methods and other sort of really non-technical methods. And we had this standard at the time, useful, concrete, and tangible result, which I would
Yeah.
say I liked it a lot. It allowed us to get a wider range of patents for a long time. In other words, there could be methods that were useful. They had some practical use, but they didn't necessarily need to be highly technical. And that's the sense in which I think there was a period of time in which the US standard was broader than in Europe. And I think the US now has narrowed. Maybe it's not exactly the same as Europe, but I find myself more often writing US patent applications to try to satisfy the European standard and then kill two birds with one stone, if you know what I mean.
Right, perfect. Well, it's exactly as you said, Robert. Well, we have the technical issues, and if you don't provide a technical effect, you won't get any grant. So, well, I don't care if the grant procedure is restrictive or not. What I need to know is the rules. How do I draft the patent application? What do I need from the client, from the inventor? And once I'm very clear with the rules, and I guess we have enough case law, which still develops, of course. Once I know the rules, I can, as we said before, transfer even the non-technical issues most of the time into technical issues, and then we're very successful with reaching a grant. And
Right.
what you also mentioned, Robert, is the drafting. Of course, when we draft for our clients, most of them do not only want patents in the US or patents in Europe. They want not only US, Europe, they want also China, Japan. So when you draft an initial PCT application, you have to also consider the jurisdictions of the individual countries. So this is why we are here to learn more about your patent practice in the US, and even further countries are of interest, as a PCT application is not only meant for the US or for the European market, but we have to do the prosecution in further countries. So this is especially why I'm very pleased to have this webinar with you, Robert.
Yeah, same here again. And for those people attending, the thing that's implicit in what we've both been saying now is that when you write a patent application, wherever the original country is, you are potentially writing that application to be examined in many different jurisdictions. And so, to the extent possible, it's really helpful to understand what legal requirements you're going to have to satisfy in multiple jurisdictions. And again, for particularly for the non-patent attorneys attending, something that's implicit and is really important to know is that the specification of the patent application, at least, is set in stone when you file, right? And so that's why we're always thinking ahead to the future in terms of what countries' laws are we going to have to satisfy years from now, because we won't be able to change the specification, and the claims we write and the amendments we make, and to a certain extent, even the arguments we make in response to rejections in countries around the world are going to be limited by the specification you write originally. So that's why it's really important to understand how the law applies now in multiple places so you can set the stage for success in as many countries around the world later.
Exactly. One thing which might be of interest for the audience, well, you have different jurisdictions. Of course, you can have like a fallback positions in the description. So when you think this might be a problem in this or that country, you might also have some options at hand in the description, which is also a tip when it comes to drafting the application.
Yeah, absolutely. And this is, not to say that software is the only type of technology that has this feature, but one of the things we're talking about is how much work has to go in to writing a software patent application that involves really transforming the inventor's concept of the invention into something that is written in the patent application in a form that's maximally likely to be granted. I hope no one takes this the wrong way when I say if you invent a new type of a razor blade, the specification of that patent application is probably going to correspond much more closely to what the inventor conceived of as their invention of the razor blade. But with software, because of the peculiar types of legal requirements that apply to it, the resulting patent application often characterizes the invention in quite a different way than how the inventors thought of it. And the purpose of that is to, again, maximize the likelihood that a patent will be granted and that it's broad. And that's why Jochen and I spend our time focusing on this to be able to produce those kinds of patents for clients. Okay, maybe I know we want to go on to some of the other requirements. These are some examples of eligible claims. I just gave some examples here. Maybe I won't go into them in detail, but I'll just point people to the fact that the US Patent Office has a really good page on their website, which includes both their guidelines and a large and growing list of examples of patent claims that have been found to be either patent eligible or non-patent eligible. So those are really useful. They're actually described in a way, I think, that a non-patent lawyer can generally understand. It explains the reasoning either from a court or from the patent office in making these decisions. And again, I refer to them very frequently. Jochen?
Perfect. Well, the three examples you mentioned on the in the first column, I guess they would be patentable in Europe as well. While removing malicious code, well, yes, there is some technical effect. It is a matter of how you would formulate your claim language. E-commerce outsourcing system also might be patentable, and digital image processing is typically also patentable. So on
Yeah.
the right column, you have again what we have in Europe: method, operator, system arrangement, computer program, a computer readable medium, and comprising. What comes after this particular word is a technical solution to a technical problem. So no matter how you name it, if you name it isolating and removing malicious code, it depends on if you really go into the technicality and provide also distinguishing features over the prior art, which have a technical effect over the prior art documents.
Yeah. I'm curious to know from you when you talk about the distinguishing features over the prior art. There's something I encounter with the European Patent Office I always find frustrating, which is they'll say, we're going to exclude various elements from the claim that are non-technical, right? And we're only going to examine the rest of it. And then I often want to say, well, the rest of it is where the heart of the innovation is, maybe, or you're excluding things that are part of the innovation. This practice they have of excluding explicit language from the claim in what they examine, to then hold that the rest of it is not patentable subject matter or is obvious or something like that, is something that we in the US find very frustrating. Could you speak to it and how to avoid or overcome that kind of problem?
Yeah, I guess it's on one of the next slides. Well,
Okay.
regarding the so-called problem solution approach, and what you named is the so-called convict approach. I personally knew the patent attorney who was involved in the convict decision. And I can tell you, well, I like it because we are used to it. That's our daily business, and it gives us a clear structure of what we have to do, of what we have to deliver, and which step of the examination proceedings or we are currently. And this, for me, the really structured process is easy, and I like it.
Okay, good. Well, I guess one thing at highlight, this is one area where things are quite different between the US and Europe, and why it's really
Exactly,
important to have
exactly.
someone who specializes in the law of that jurisdiction prosecuting a patent application. Disclosure, written description enablement. Again, for non-patent attorneys, this means what is it that you have to describe about your invention in the patent application? Let me just say, at the highest level in the US, the requirements for for the amount and kind of detail you need to describe have generally increased over the years. When I first started practicing patent law in relation to software back in the mid 1990s, you could file fairly short, high-level abstract descriptions of the algorithm, let's say, and that was enough. And increasingly over the years, the US Patent Office has been requiring us to provide more detail in the specification about how the algorithm, I say algorithm, how the software works, how it does what it does. It's not enough to just say it achieves this result. You need to describe the steps that achieve that result. And in the case of AI, for example, we are certainly erring on the side of describing how a model is trained, what kind of training data is used, what kind of training method is used, particularly if we're going to be claiming anything related to the method of training. We would be concerned about only saying the invention trains a model that does the following, because we run the risk of having the application rejected for lack of enablement. And again, back in the 90s, even 2000s, it was quite rare for a software patent application to get rejected in prosecution for lack of enablement. And now it's much, much more common. So it means we're writing longer, more detailed patent applications. It does require more work. It does require more thought on behalf of the patent attorney and the client. But it does make for a stronger patent, both in the patent office and in litigation, if the patent is ever litigated.
Perfect. Robert, you were addressing several issues. Well, first of all, the AI issues. Well, as we handle software patents, some clients or applicants come up and say, well, I made an invention. We gonna do whatever we did before, but now we use AI. So this is a typical problem of enablement. If you use the AI as a black box, you will have this problem because a black box cannot be claimed, of course. So when you come up and say, well, I made an invention that refers to AI. So the question is, what are you doing? Are you just applying AI, or are you really developing AI issues further? So, if you really develop the AI further, of course, that is patentable or can be made technical. If you say, well, we use AI as a black box, there is really a problem of enablement. So, the inventor is the inventor, and the audience, say the skilled person, is not the inventor. Meaning, if you are the inventor, you have to demonstrate how the invention shall be performed or executed. So this is a matter of enablement. If you say, well, it might be this and that, so if it's up to the audience, so the skilled person to identify how it is performed, then it's not enabled. So you have to provide at least one way of carrying out the invention, and there is some space. You don't have to not address each and every issue, which is commonly known. It does not has to be addressed. And yeah, this is well, enablement is typically a problem with the so-called black box inventions. They lack enablement, and once you have that black box, the patent attorney has to investigate further and find some other issues, which
Yeah.
are then patentable again.
Yeah, and although, as I've been saying, the US Patent Office has been requiring more enabling detail over the years, and it can be frustrating because it requires more work. I actually find it does help develop better patent applications when I'm working with a client and they say, yeah, we're using AI for this function. And I say, how? How are you doing it? What are you developing? It does push
Exactly.
them to have to describe what it is that they've done, and even helps them to determine whether they've come up with something that's innovative enough to be patentable. Helps me evaluate it. So better, I think, to err on the side of including some more detail. and going through the process of having to describe the detail, because it helps us determine whether we have something that's really worth filing a patent application for, and then it helps ensure that we have enough there to obtain a patent and make sure that the patent is strong against any challenges to its validity.
Exactly. One thing with we were talking about those so-called black boxes. The other issue which is related to that is that of the goal to be achieved. Well, if you say I have a method for improving the world, this might be nice, maybe technical at least in part, but what are you exactly gonna do? So the thing of with enablement is the technical teaching. What are you exactly doing? What are not only the goals to be achieved or what black boxes are involved, but really the technical teaching has to be clearly provided.
Right. And then, on that point, what we as patent attorneys provide is we take, here's the goal to be achieved. And then, as you just said, we push, how do you implement it? So we're going from broad to narrow, you could say. And then in the claims, though, we'll try to broaden again as much as we can, right?
Exactly.
There's a back
I
and
like it.
forth process, back and forth. Because we don't want, although it's necessary to understand the technical teachings and to describe the technical teachings, we don't want to limit the scope of the patent to those very specific teachings. So we'll stretch the boundaries as much as we can in the claims. And then I'm sure you'll encounter this. I see in your point here, we have something similar in the US. Sometimes the patent office, if we have a claim that is broader than the specific technical teaching, they'll push us to try to narrow the claim down, and then we'll argue that the innovation is broader than that. Yes, we had to describe the technical teachings in the specification, but we shouldn't necessarily be limited to one, let's say, specific implementation in claims.
Exactly. Well, our goal is to claim the idea and not go into detail too much, which of course is in conflict with enablement. But every now and then I have clients that ask, "Do I have to provide the source code?" Well, you can. You don't have to. What we do is that we claim the idea that is behind the source code. So the claim should cover all implementations independent of the programming language. So there is some kind of conflict between enablement and maybe broadness because regarding enablement you have to provide precise steps, and regarding the broadness, the scope of protection, you want to go
Absolutely.
really broad.
Yeah.
So this is our job to
This
handle
is
to balance these issues.
right, right, right. Okay, novelty. Maybe not too much to say here about software that's different from other types of technology. Again, for those of you not patent attorneys, it means that an invention to be patentable has to be new, which means it has to be different, essentially from technologies that have been available to the public, that have been sold, that have been published, that have been in public use, that have been known to the public in some way. I think the only thing I added here that may be software specific is that in recent years, there's just been an explosion of available publications about software, including things I put online sources, GitHub and archive. I mean, people are able to self-publish their own papers immediately, essentially. And so the speed at which either actual source code or academic papers about new kinds of software, the speed and volume of those has just exploded in recent years. So that just puts pressure, I would say, on anyone who wants to pursue a patent application for software to file it more quickly and sooner, because you don't have that delay you used to have between when your competitors developed something and when it became publicly available. I mean, now you need to assume that if a competitor, I mean, including in academia, I find academics, they want to publish what they've done immediately, and they now have the ability to publish immediately because they can just post their paper on archive, or your competitors can just post some open source code on GitHub. I mean, they don't have to go through a long publication process that they used to that would take months or a year. So that just puts huge pressure to file patent applications soon so that you're not predated by someone else.
Well, let me add something. We have the same later published but earlier filed patent applications are available as prior art. Well, we have the same on a national basis in Germany as well as on European basis before European Patent and Patent Office. And one thing which is really an exception is the German approach of a German utility model. If you publish something and that is your own publications, you have like a grace period of 6 months, and also oral disclosures are not considered with utility models. So this might be an option if you have already disclosed your invention. This is really an exception which is broadly used, where you can get protection even for a published invention under some circumstances. So if you think you have already disclosed your invention, you might consult also a German patent attorney, and we will check if there's still the possibility of obtaining a utility model. But having said this, there's also a downside. Well, you can only claim apparatus claims in a utility model, and software is typically a method claim. So we have to somehow transfer your method into an apparatus claim. But still, there is options, and it's also pricey. So that is something really that is a difference compared, for instance, to the European practice.
Very good. And I just want to be mindful of time. I don't see any questions in the question and answer. If anyone attending does have a question, please feel free to post it in the Q&A in the webinar. We'll be glad to answer it. And the last thing I'll say on novelty is, I'm always surprised that there's still a lot of people in the US who aren't aware that the law changed over 10 years ago here. We used to be in the US what's called first to invent, meaning that if you invented something today and someone else invented it tomorrow, and they filed a patent application before you, you could overcome them by demonstrating that you invented before them. And I say that because in the US, that led to, I wouldn't say complacency, but people felt they didn't have a lot of pressure to file patent applications quickly because they thought, well, even if someone else files before us, we can demonstrate that we invented before them. And I find a lot of people aren't aware that changed in the US. Again, over 10 years ago, we have now long been in what's called first inventor to file, similar to first to file elsewhere, in which case it generally doesn't matter when you invented. All that matters is when you filed your patent application. And that's, again, why there's such pressure to file the patent applications quickly.
I guess that is more practical, the new approach.
Yeah. Non-obviousness and inventive step. Again, probably not so different in software than in other cases, other than maybe it's a little trickier to apply, but than in some other fields. I mentioned here that interestingly, when it comes to AI, the US Patent Office has been seeking public comment on the issue of if there's so much AI generated content out there. I mean, I've seen estimates that over 50% of the web might be AI generated now, as people are just flooding the web with AI generated websites and blogs and all of that. But for patents, it raises the question of if there's AI generating descriptions of technology and software and actual code, can that be available as prior art to be used against patent applications? That's what the USPTO is seeking comment on. Otherwise, I think the issue of inventive step and non-obviousness, it can be tricky to apply in practice to software to decide if you had an algorithm in one field being applied in another field, is that obvious to do or to combine different things? Otherwise, probably law of non-obviousness, not that different in software, unless you have a different opinion.
Yeah, well,
Uh,
yeah. Uh, no, no, I'm good. I thought you were skipping to the next slide. Well,
yeah, yeah.
regarding yeah, Robert.
Yes. Okay. Examination procedure. I think we've somewhat talked about this earlier on when we talked about patentable subject matter. The US, based on a bunch of court cases, has its own particular process for uh, analyzing whether a software claim is directed to patentable subject matter. And it's a two-step process, and the second step has sub-steps. This is what the guidelines step us through. It's very non-intuitive, I would say. And so this is, I think, probably the most important area where you need a specialist who's really familiar with what the guidelines are. Because if you get a rejection of your software claim, for being non-patentable subject matter, the patent office will really only listen to you when you respond if you go through this two-step process and follow the guidelines. And I'm
Exactly.
smiling because I've seen people try to respond just based on logic, based on their own understanding of their invention, and the patent office doesn't care really if you don't comply with this two-step analysis that what's called the Alice/Mayo test. You have to follow it, and it's the only chance you have of overcoming a rejection.
Exactly the same in Europe. In Europe, we have the so-called problem solution approach, and European Patent Office is very strict with this. So if you argue against a communication, you have to apply this approach, which again I like because it's a structured process. So what we do, we have several steps like determining the closest prior art. Then you do have to identify a distinguishing feature. This distinguishing feature needs to provide a technical effect. And from that technical effect, you define the objective technical problem. And once you have that problem defined, you go to the prior art documents, where this is also different to US practice. We have typically we have like two documents. One is the closest prior art document showing the most common features with the invention, and those distinguishing features that are examined, they have to provide a technical effect. So once you have the objective technical problem, you go to the closest prior art, and you examine the distinguishing features. And the so-called convict approach is that if you have mixed type inventions with non-technical and technical features, only those are considered which are technical. And then you also have the so-called could would approach. You take another, at least one further document, and then you discuss, could the person skilled in the art have combined both documents, or would the person skilled in the art have combined both documents. So there needs to be some kind of indication, or at least no hurdle not to combine those two documents. And I see in US proceedings that lots of prior art documents are combined here and then, and we have a lot of issues with like three documents. So in Europe, we have a clear process where we typically combine only two documents, namely the closest prior art document and one further document. So this is really a difference compared to US practice. But I have to say, I like the European approach better because it's more precise and more structured. We don't have the discussing of all those documents in any combination. So this is my very personal opinion.
Yeah, and I think I agree. On the patentable subject matter side of things, this two-step approach that the patent office defines, look, they've done their best to glean this from the case law and to describe it as if it's a very structured, objective approach. But in practice, it's very subjective. There's a lot of room for subjective opinion about what does and doesn't fall within any of these judicial exceptions, like a law of nature or especially an abstract idea, or even a mathematical concept, because as we keep saying, really, you could say that any software performs mathematical or at least logical operations. And so it's not really that objective a test. Most of the arguments end up coming down to this final step 2B, which is even if you have I'll go back to compressing data, right? You could say, well, yeah, it is a process, but a claim that says you take the original data, you perform these operations on it, let's say they do some math, right? Then you're going to, the conclusion here is that the claim is directed to a judicial exception because it recites some mathematical operations. And so then your only way out, in other words, your only way for arguing that the claim is directed to patentable subject matter is usually going to be in this final step. And that's where you're going to rely on that long list of factors that I had in an earlier slide. Does this represent a improvement to computer technology? Does it transform data into a different state or thing? And you rely on previous cases, and if possible, point to previous claims that the patent office or a court has found to be patent eligible. And still quite subjective. The answer you get often varies depending on what examiner you have, and if the examiner won't agree with you, you might have to appeal. Drafting tips, I'll just mention the first one. This is probably the biggest one. I said it earlier, particularly if you're going to be filing in multiple, if you think you might be filing in multiple countries or jurisdictions, pay really careful attention to patentable subject matter, patent eligibility from the beginning. The more you can write the specification and the claims from day one to make the best case for patentable subject matter and to build in arguments against rejections, the easier your life will be later when you are prosecuting the patent application, because it can be difficult to add those in later. I don't know about in Europe, to a certain extent in the US, if there are things lacking from the specification, you either won't be able to argue them, or you might need to get what we call Rule 132 declaration, an affidavit from an expert testifying to additional facts that are missing from the specification. It's much easier to put all of those things into the patent application from the beginning to the extent you can. And how do you do that? You have to try to predict the future a little bit. And the best way to predict the future is just have lots of experience handling these types of patent applications.
Exactly. Well, what you're just saying is my second point on the right. Exactly. Disclose a technical effect for each potential claim feature. So what is a potential claim feature? Of course, a potential claim feature is not in the claims yet, else it wouldn't be a potential claim feature. So this refers really to the description. So once you get a rejection from the examining division, and they say, well, we have examined all independent claims, everything, there is no technical contribution, you might want to go back into the description and find your drawback positions in the description. So at the time of drafting, it would be nice if you already disclose a technical effect for each and every feature that might be in future be part of the claim. So you have them at hand. And once the examiner asks and says, well, okay, this is a new feature, but what is the technical effect? You might say, well, I have it on page here and there. So this really provides huge opportunities where you can save a application that has been rejected and still get a grant. So just confirming what you're saying, Robert.
Yeah, very good. And I just noticed, so we're at an hour. We're glad to stay here longer. I want to be respectful of people's time. We do have a couple of questions that I saw have come up. One of them is someone who said they were looking if you could re-explain or clarify the black box analogy you mentioned when you were talking about AI issues. I think that was probably when we were talking about enablement.
Does this refer to me or
Yeah, I think it was to you. I mean, I'm glad to address it. I think it might have been that you were saying we can't just say that an AI system is a black box. We
yeah,
have to maybe describe how a model
yeah.
is trained or how a model is being applied within a system and provide some technical details and not just say what result it achieves.
Well, regarding the patent, the deal is you get a protection and somehow you have to give something back. So what are you giving back? That is a clear technical teaching to the public, saying, well, I have an innovation, I have a new idea, and you have to clearly provide what is your contribution, what are you exactly doing? So you have to provide a step-by-step analysis of, say, algorithm this first, then this and that. And so if you only provide like a black box, so this is not really a technical teaching. So, well, if you say we're gonna improve hardware storage issues and we're gonna apply AI. Okay, well, this is no technical teaching. Anyone can apply AI as this is what it's meant for. So there's this general purpose AI, and so this is not an argument anymore. So we have to distinguish. Are you really developing further the AI issues? Say, are you providing improvements in hardware efficiency? In which step of AI development are you providing a benefit? Maybe gathering the data, training the data, applying the data. So, is this really an invention that is a contribution towards AI, or are you just applying AI? Which is, of course, its normal use. It's if that is the normal use of AI, there is no contribution. So you have to make sure to really provide the audience with a clear technical teachings. What are you going to do and what is the technical effect without these black boxes? That is
Yeah, I mean,
the discussion of enablement, I guess.
yeah, I mean, and I mean, I'm sure you saw this. I remember after ChatGPT came out, I had lots of people coming to me with I thought, very good ideas. But I'm thinking of using ChatGPT to do the following. A lot of people were coming up with coaching application. I'm going to use ChatGPT as a marketing coach. I'm going to use ChatGPT as a patent attorney, a coach for patent attorney, and that's great. But as you said, that's really the intended use of a chatbot like ChatGPT. That's something it can almost do out of the box, really. And so then the question is, well, what are you contributing to ChatGPT that makes it a better coach than it would be just out of the box? And if you don't have a good answer to that question, then your patent application will fail on several grounds. You won't have any technical teaching to provide for enablement purposes, and you'll probably fail for being obvious or lacking inventive step. Probably a number of grounds. So it's a good idea for anyone out there who's innovating to ask themselves this technical contribution question. And it's our job as patent attorneys when someone comes to us and says, I have an invention and it's just to use AI for this purpose. It's our job to push back and say, great, what did you do to make it possible to use AI for that purpose? What did you contribute? What problem did you have to overcome to make it possible to use AI in that way where it wasn't possible to use AI in that way before? And if there are no answers to that question, then they probably don't have something patentable. And something I tell people a lot is you might have a great business idea. You might have something that would be valuable for you to provide as a consultant to people or even as a product for a while, maybe a year or something like that. It doesn't mean you won't be able to make any money off of it, but you might not have anything that's patentable because for it to be patentable, you have to solve a technical problem.
Yeah. It's been the same with blockchain, where people came up and say, well, we're using blockchain without really describing what they're going to do inside that blockchain.
Yeah, blockchain has lots of good intended purposes in many industries and many fields. But when
Yeah.
you apply it in any of those ways, you're using it for its intended purpose. It might be in a new industry where it's not being used, and therefore people will pay for it because they don't have, let's say, the coding ability to write an application that uses blockchain in that way. But that doesn't rise necessarily to the level of patentability. Next question we had was, there exists a big uncertainty in US between the MPEP for patenting software and later on, I think what this person is asking is that, or saying, is that the US Patent Office will grant patents for software that sometimes or later, those patents are invalidated by the US Court of Appeals for the Federal Circuit. Or the question didn't say this, they're sometimes invalidated by the Patent, Trademark, and Appeal Board within the Patent Office, and that there's a disconnect. And it is true. It is true. And it's frustrating, I think, for patent applicants that the same standards of patentability are not being applied by the Patent Office in its examining division, so to speak, and in the Board of Appeals or in the courts. And I'll just say that is true. It is true. There's different, really different standards, and it creates uncertainty, right? That you
Yeah.
might obtain a patent, invest in a patent, get the patent granted, have in theory what we call a presumption of validity of the patent here, and yet it's become easier largely as a result of the American Invents Act and the PTAB to invalidate patents. And there's a lot of efforts out there for patent reform in the US. I hope some of those go through, which would restore some more equality in how patents are evaluated when they're examined versus how they're evaluated after the fact. As a practical matter, the main defense that I try to apply for my clients against that is to just write more thorough, defensible patents in the first place, and usually to obtain portfolios of patents that provide a range of different types of protection so that even if one patent or some small number of claims are invalidated later, we still have enough protection left over that it's enforceable against infringers in the way. It's an imperfect solution, but that's generally the way we handle this disconnect.
Yeah, well, in Europe, the situation is even worse. You can have a European patent granted before European Patent Office and validated in Germany. So the funny thing is that you can have patent protection in Germany without even addressing the German Patent and Trademark Office. They are just granted by the European Patent Office and validated in Germany, and after opposition period before European Patent Office, you can have nullity or revocation proceedings before German courts. So the patents really that are granted before European Patent Office are then again assessed before German courts. And there's what is applied, of course, in German courts is not the EPC, the European Patent Convention anymore, but rather the German patent law. So this is the same problem that we have, which is even worse, I guess, in Europe and in Germany compared to the US. So this is really an interesting question.
Very good, very good. One more question. We may not be able to address all of the questions, but one more question. And the example of isolating and removing malicious code, that was one of the examples I gave earlier from the Patent Office of patent eligible claim. How do you establish technicality? It looks like handling pure information. So that's a good point. So, in that case and in some other cases, the reason that the Patent Office, or in some cases been the Federal Circuit, has held the claim to be patent eligible is because the problem that's being addressed is something that they consider to fall within the realm of computer technology. The DDR case, I think I cited in one of the earlier cases, one of the earlier slides, said that the problem was one that was necessarily rooted in computer technology because it involved a processing a hyperlink to generate what was a composite web page, right? And the court said, well, processing links and navigating through links on the web and generating web pages, those are all inherently or necessarily related to computer technology. They are not just pure abstract mathematical operations. And that was enough. But I understand the question because, the court didn't look so much into, well, were the steps in the solution mathematical in nature? If you examine that in detail, you might conclude, well, the steps being performed to navigate a link or to create a web page, you could characterize those as mathematical somehow. So what this points out is that the answer to the question depends on which direction you approach it from. Do you approach it from the direction of, is the problem being addressed one that's within the realm of computer technology? If so, I think you'll usually find more frequently that the invention is patentable subject matter. Once you start asking, are the individual steps mathematical in nature, you could almost always conclude that they are in the context of computer technology. So we as patent attorneys argue whatever we can, right? In the case, we write the patent application to emphasize the computer implemented aspects of the invention in how it's implemented and the nature of the problem that it's addressing. We do both. And then if we get a rejection, we'll argue whatever is best for us that we can. Because I understand that in theory, right, you could say every computer implemented method it always has some mathematical aspect to it, because that's the nature of what a computer is.
Well, let me just add something. Of course, there's been a US case, but from a European perspective, this would be patentable as well. I think we have in the guidelines a very specific case law addressing security issues. And typically, these security issues are considered to be technical because this is implicitly within the computer and involving technical means. So also in Europe, I guess this wouldn't be a problem. So removing malicious code at least can be formulated to provide a technical contribution. So I guess referring to the guidelines and my personal experience, we would receive a grant in Europe as well.
Yeah, understood. Okay, some examples. Jochen, I'll let you speak to this. Was this a patent of yours that you got granted, or is this a patent that
Well, this was a patent that is highly interested. As I told you before, EP grants can be validated in Germany and challenged before German courts. So this was filed like in the year 2000 with a priority of 1999. And it treats a method of presenting data. So we have this exclusion from patentability, which did not get into effect in this thing, because as you will see in the following, we have several structural and technical features like a data storage device, data server. So the data is presented to a user. Said user accessing said data server over a network, where in the process between accessing the server and presenting the data, at least one data path is used. So what you see is typically a really common claim language. So you might consider this to be part of the prior art. And what really made the difference is the control data associated with the selection of data that is sent, said at least one data path being unidirectional. So you have to see, you see that you don't have to provide each and every structural feature. Most of them are implied, and here you have a technical benefit, like a technical contribution, as you're providing security of the computer system. And this is what we were discussing before with the security issues. This is a very broad claim which got granted before European Patent Office, and it was challenged before Bundespatentgericht, meaning a German court, and even a German Supreme Court, BGH. So the result was that this patent was fully valid. So you see a very broad claim with some technical features. Most of them are implied as they run in a computer environment. So this is really a broad software patent that is really fully enforceable and fully valid, which was held by the German Supreme Court. So this, I think, is a very nice example for a valid software patent, both before European Patent Office, so European practice, and German courts, meaning German patent practice.
Yeah, I mean, this is, I think, really helpful. One reason I find it interesting is that, it doesn't have like a real sequence of steps, which you normally would see, right? It's not,
Exactly.
you do this, then that, then this. It is quite abstract, and it's more of a description of the features of this software.
Exactly, exactly. Well, as you see in the figure on the left-hand side, of course, there is some sequence of steps, but this is rather implied. So this is the figure one is rather an enablement. So you might perform this differently. But as you said, well, there's just a technical teaching that is very common, but has a very clear distinctive features, and as they contribute to the security, so to the technical problem of computer environments, that was really allowable. Well, I like this example.
Yeah, very, very, very interesting. I'll just mention one. I have two of my own that are fairly recent. I'll just show one of them because it relates to healthcare. I'm sure you have this too. I really love working on patent applications that relate to healthcare, because they really help make people's lives better. And so this is a patent I received for a client fairly recently, I think within the last year or so, that involves software that can understand, let's say you have a chronic health condition like diabetes or breast cancer. We know that it's hard for your healthcare providers to keep track of what is the current state of your cancer, for example. That information might be spread across multiple different software systems. It might be stored in the form of lots of very detailed data. It makes it hard even for your doctor, much less for you, to get like a summary of exactly where do you stand. And then, of course, your health condition evolves over time, and then the data may become out of date. So this is for a part of a system that analyzes data about a person, understands, you could say, the state of their chronic health condition, and summarizes it. And I think it uses some natural language processing. You could say AI in a sense, and reasoning to reason over different types of data about a person. And I think even a fairly non-technical person could probably read through this and understand what it says. You take a first instance of a data model. So that's like a model of a specific disease like breast cancer, which says, here's the parameters of that disease. You might have a stage, right? You might have stage 1, 2, 3, or 4. And then essentially the rest of these steps are getting a request from someone like a doctor for information about the patient's disease. And this takes the data, processes the request, and gives an answer to that request that's in response to the request for information about the disease. And so it's definitely more detailed than your example. It does have a sequence of steps, but it's not, I guess the main one takeaway I'll give is it's not at all at the level of code, as you said. It's a much higher level than that. And although you might say that the problem it's addressing isn't a technical one, and you might think we'd have challenges in a medical method because that's not inherently technical. The steps involving processing of data were considered technical enough to be patentable subject matter, and of course everything else distinguished over the prior art. I'll skip over this one, but it's again, fairly high level. I just like to point out to people who sometimes think that for a software patent, you need to define extremely detailed steps, again, near the level of code. Really not necessarily the case at all. And anyone who wants, you can look these up, contact me offline if you want to find out more about what this was. There's also a healthcare related one for keeping track of implements used during surgery to track them. We're just about, at our extended period of time. Thanks to people who have been sticking with us. I know for the US, you're in the middle of the day, Europe at the end of the day, maybe getting ready for dinner or something. And we might have people from even more extended time zones around the world. Any other questions or comments? And while I say that, I'm going to put up here a bunch of different ways for you to reach out to both of us, find us and our firms. We've got our LinkedIn links. I know we're both pretty regular in posting on LinkedIn. You can scan these codes. Those are for our LinkedIn profiles. These are our URLs for our firm websites. Feel free to visit those, contact us on LinkedIn or in any other way. Jochen, do you have any final comments before I make a final request for any questions or feedback from the audience?
Well, we had a lot of issues covered, and I really liked the webinar. Thank you to Robert for hosting. That was really a pleasure. So we learned much about US and European patent practice, and indeed there are some similarities, but also very much differences as well. So thank you, Robert, and it's been a pleasure. Whenever there's some further questions regarding the European practice, you can directly contact me.
Yeah,
Thank you, everyone.
absolutely. And again, to what you just said and to the audience, I think one thing we've seen throughout the webinar is that a lot of the same types of software can be patented in both the US and in Europe, but a lot of the details about how you would obtain those patents can be quite different. Particularly in how you might respond to rejections at the US or European or German patent office. And you really, really need someone who is a specialist and who is very experienced with responding to those types of rejections to handle them, even if the end result is to get a patent in the US and a patent in Europe that cover the same basic software. If you don't have someone handling the prosecution of that patent application who's really intimately familiar with how to get to that result, you could hit a roadblock that you won't be able to overcome. And that's why I always go to someone like Jochen in Europe to prosecute patent application. In fact, I wish I could do it more for clients. For really valuable cases, I'll go to a European patent attorney even before filing the US patent application to try to make it as strong as possible for use in Europe. And that's something I, at least to those of you in the audience, suggest you think about, at least for your most valuable patents, is to get some input from patent attorneys in multiple jurisdictions so that you minimize the likelihood that you'll hit a roadblock you can overcome and maximize the likelihood of protection in multiple jurisdictions.
Exactly. That's why this webinar was so helpful. Thank you
Thank
again,
you.
Robert.
Thank you so much, everybody.
Have a great
And
evening, everyone.